You've been in a crash, so naturally you get on social media to vent your frustration and show the world what went down, right? One problem. Guess who just destroyed their best chance at recovery? Welcome to the Biker Rebellion. I'm your host, Ginger, here with attorney Pete Leahy, founding member of the Biker Lawyers. Now, Pete, in that opening scenario, why is a simple social media post so potentially damaging for a crash victim?
Things that are put in writing can be misconstrued. They can be taken out of context. You just don't want to give an insurance company or their lawyer any artificial means with which to diminish or belittle your lawsuit.
Let's imagine I've just returned home from a thrilling ride to Sturgis, right? It was a blast. I've got tons of photos. What's the harm in sharing those moments with my family and friends through, let's say, Facebook?
Do you want to screw up your lawsuit?
No.
That's the harm.
Okay.
The simple rule with social media posting after you've been in a crash is don't do it. Just don't do it. There's no good excuse to do it, and there are 1,000 good excuses not to do it. You might have a terrible recovery after a motorcycle crash. There might be one photo you posted on your social media months after the crash where you were doing something enjoyable and you've got a big smile on your face. Things can be used against you. Things can be taken out of context. They show that to the jury like everything's been happy and rosy the whole time ever since your crash, but it's just one picture. Try explaining that to them. Try explaining your way out of that hole, because that jury looked at you when you first walked into the courtroom and thought you're trying to trick them anyway. So just don't post about your case on social media, period.
Does having a private profile offer any protection if I'm only sharing with family and friends?
No. The insurance lawyers are going to ask for things that you've put on social media, whether it went out to the general public or whether it went out to specific individuals. The judge is probably going to give them access, whether it was on a public posting or whether it was a posting, for example, that I sent to you and a small group of people I know. If you're communicating about the case, it's discoverable, so it doesn't matter how big or how little the posting is and how public or how private it is.
So this would also apply to just vacations you take with family and friends, things like that. Whatever it is, if it gets posted up, it's going to be discoverable.
Yeah, I mean, it's always discoverable, but the discovery of,
have you been on any vacations since your wreck?
yes, and you give them the details of where you went, that's a lot different than 100 pictures of you flying down water slides and doing all kinds of stuff that looks like a great time that can be taken out of context and used against you.
Now, let's say we're not doing happy vacation photos. Now we're doing more of treatment. We're venting our frustration. And let's say, I wake up, I'm in pain. My back hurts. I get on Facebook or TikTok, wherever, and I post either a video or just some text and say, I'm in pain. This hurts. This sucks. Just something like that. What's the risk there?
Save it for your therapist. Don't put that shit on social media. There's absolutely nothing to be gained by putting information about your case on social media. The only direction it can go is badly. Just don't do it.
So there is a substantial risk to posting about your treatment progress. Even if you're saying,
Hey, my doctor said this.
and you're posting it out to the world, there's a risk there as well.
Well, you just waive physician-patient privilege.
Good point.
Just don't talk about this stuff on social media, period. No excuses, no exceptions. Don't do it.
Now, let's say I'm in physical therapy, right? And they ask me to leave them a positive Google review or a testimonial from my doctor or therapist talking about their treatment, like 5-star, 3-star, whatever. Can that be used?
Yeah, can it? Yes, it could. I mean, if the insurance lawyer finds a posting where you said, this physical therapist is a magician, he made everything all better and totally went away. It's nice that you gave that physical therapist a very nice compliment. And if it was accurate, then you'll testify to that anyway. But let's not go putting it out on social media for the entire world to see.
When do the insurance attorneys and the defendant, when do they gain access to the social media, and what are they hunting for typically?
When they gain access to social media depends on your privacy settings on your social media. It might be right away. It might be instantaneous where you file the lawsuit and the defense lawyer looks you up on social media and it's like, okay, there he is. And they copy everything they can find because they're afraid you'll take it down later. And that's if you have very public settings. If you don't have public settings, they can still ask for, and a lot of judges, maybe most, will order you to produce information on social media about your physical wellness.
Gotcha. And what about after the trial? Do I need to be worried about what I would post after a trial or after a settlement?
When the case is over, it's over. You can do anything you want. You can run naked down Main Avenue for all I care.
Fair enough. Now, what about talking person to person? It's not getting sent to the world, so to speak. Are those discoverable?
Anytime you say something to somebody about your case, it's discoverable.
Okay.
So if you had a conversation with your brother about your case, that entire conversation is discoverable to the extent that your brother can remember it to talk about it. If that conversation is on social media, there's not going to be any question about whether it can be remembered because it's right there in black and white or whatever color the font might be. Conversations where you talk about your case, about your injuries, about how you feel, things you're doing, that's all discoverable.
Do I have to give the insurance attorneys my login information for this?
Some judges will require that.
Could I avoid this whole headache by just refusing? Just saying, no, I'm not going to give it.
No, you can't. Once you file a lawsuit, you're subject to what the judge orders. And if the judge orders you produce this, you're either going to produce it or your case is going to go bye-bye.
Let's say that we're in a personal injury case and I've got posts from years before we filed the lawsuit. Can those be dug up and used against me?
Potentially.
Whether they're relevant.
Your comment about whether it's relevant really cuts to the chase because in discovery, when you start out, what the other lawyer can find out about is really, really broad. It doesn't have to be relevant. It's a very, very broad standard. By the time you get down to trial, the funnel narrows down and only that which is relevant can be used at trial. So just because, for example, we produce something that a client has posted on social media, that doesn't mean the other lawyer gets to use it. It still has to be relevant at the time of trial.
Let's say a friend tags me in a post or mentions me in a comment related to the crash. Does that have the same implications as if I posted it myself?
No, it does not, because you didn't post it yourself. You had nothing to do with that post. Therefore, it's not discoverable because you didn't do it and you're not in control of the information.
There's a newer thing, and I guess newer in relation to the internet at large, known as check-ins, where you walk in to a gym, for instance, and your phone just automatically dings like, you're checked in, right? Can that be used as evidence against my claims?
It could potentially be used as evidence. For example, if somebody's testimony is that they are incapable of walking more than 15 or 20 yards and they spend their entire day essentially laying down, immobile. And then if their phone or their social media is showing check-ins at the gym day after day after day, that's inconsistent and it sure will be used against that person.
So what about the story feature? I think we all know there are platforms like Instagram, Snapchat, Facebook, where you can post a story and it disappears after 24 hours. Are these safe to post, or can they be used against me as well?
I suppose it would be safe, if not foolish, but somewhat safe to post because it's going to be gone in a short period of time. But somebody can always grab it while it's still up there, I would assume. I mean, you can screenshot stuff, you can record stuff. So no matter how safe you think it is, don't do it. Save it for when you're testifying in a deposition to the other lawyer or at trial. Social media is not for you to express how you feel about your lawsuit.
In other words, if a lawsuit is getting filed, it's time to go dark on social media platforms with anything pertaining to the lawsuit, anything that could be construed for the lawsuit.
Yeah, you absolutely cannot help yourself by anything you might post on social media. You can only hurt yourself.
We've talked a lot about the major social media platforms. What about other online biker communities, for instance? Are these areas of concern as well?
I don't care how mainstream or how offbeat it is. Do not post about your case on social media. Don't post about how you're doing on social media. Don't put pictures up of your injuries on social media.
Now, let's say I've already done it. I've already made the grave error of posting about it on social media, and I have second thoughts and I want to delete the post. One, are those ever truly gone?
I don't believe so.
Two, does the timing of the deletion matter?
Yes. Let's break it down. Number one, is it ever really gone? I don't think so. I mean, I'm not a computer guy, but from what I understand, it's never really, truly gone. If it was ever on your social media account and you delete it, if a lawyer for the insurance company wants to dig that information out badly enough, they can hire somebody who will be able to extract it. So I don't think it ever really, truly goes away. Your second question was, what about the timing? Does that matter? Yeah, it matters, because if you maybe posted some stuff and thought better of it and deleted it, that's one thing. But if your lawsuit is already on file, things are moving forward, and a discovery request is made for your social media information, and before we produce the information, you delete it, that's going to look really, really bad. Because now you know the other side wanted the information, and you deleted it knowing that they wanted it. So yes, the timing can matter very much.
The internet is written in ink, and whatever you say can come back to bite you in the ass. So think before you post, and think before you direct message your friends. I mentioned at the start of this video that posting on social media can destroy your ability to recover after a crash, but that isn't the only pitfall you need to know for your lawsuit. Check out our video, 5 Ways to Protect Your Rights If You Get Into a Bike Accident, where Dan will explain the mistakes that bikers make in a crash.